just give me a call, shoot me an email. I'm happy to help you with your business. I want to now, without further ado, introduce our wonderful speaker. It's so timely, as all of you know, with all of the collections getting ready to start and all the changes happening within our environment right now. We so appreciate Gina Whitlow being here from the Western Collection Bureau, and she's going to talk today and speak about the collections for landlords. So Gina, I'm going to let you introduce yourself.
Thank you.
And thank you for coming.
Yes, thank you. This is a bit of a conversion, right? Usually we're either a year and a half ago, 2 years ago, we were walking around the room doing seminars and talks like this. And so this is a little bit, I think most of our guests are on Zoom, right? So I'll convert a little bit because I usually do a little bit more of an interactive thing. I tend to be kind of competitive in my personal life, and I like to bring that and make a talk about collections, which is technical sometimes and a little bit dry, into a little bit more of a fun thing. So I don't know if, just let me ask a couple of questions. If I pose some questions, are they able to tally online or give me a score at the end? Or if I gave them, they have a chat or whatever. Okay. Well, I'll keep it simple. If you do have questions, put it in the chat box. This is a continuing education class, so I want to make sure everyone is walking away with new information. A little history about me, a little background professionally. I've been in the finance and credit union and collection industry for about 28 years. I grew up in the credit industry doing collections, repossessions, foreclosure, turned that into a debt management program that I do now. And I've jumped over to the collector side, and I'm currently with Western Collection Bureau. We are, just a little plug for our company, we tend to be the exception to the industry and the greatest collection agency available. So my cards are over there at the end of the day. But it isn't a plug for our company, really. It's just a very timely thing right now for those of you in the real estate industry and investors and landlords and all that with, and I don't think anyone has said the word yet, pandemic. But that's right, the elephant in the room, that everything has pretty much changed in our lives in the last year and a half because of this pandemic. So as we're just trying to come out of it, where we are sort of in time is that, as you know, the moratoriums on for landlords with evictions, we're getting toward where the moratorium is expiring. We're getting toward the point where landlords are going to be able to begin to collect again. But the law didn't put, so all of this back rent that we're facing is going to be an issue, clearly, right? I want to walk you through some of the ways, the main focus of today, the main goal of today's talk is for landlords to get the information on how they're going to collect this money that's backed up. Because the one thing good about where we are now is all of the back rent isn't just forgiven, it's still there. The law didn't make it go away, but how in the world are we going to collect it? One of my areas of expertise is bankruptcy collector or creditors' rights in bankruptcy. So I would highly anticipate that we're going to see a lot more of that. So that's going to be something that landlords are probably going to be facing. And I don't know how much exposure people have to that or landlords have to that. We won't be able to get into that very much tonight with the time allotted. But again, my business cards are available, and I'm available in the industry. So if any of this stuff turns out to be stuff that you want to talk about after the meeting or a session, to do definitely get in touch with me and let me know. So just to get into the meat of what we're here to talk about today, we want to talk about how landlords are going to get the unpaid rents back. First of all, I'm in your shoes a bit too, because I'm a landlord, and I can only imagine if you're like me when this whole pandemic started and people are not able to pay their rents. We sort of, and this is true for the collection industry too, right? When we're trying to collect anything, we kind of look like the bad guys. The industry or the laws are very favorable for consumers, which is good, and a lot of protections are provided. We happen to be on the other end, and we still have mortgage payments to make, and we still have to answer to our lenders. So clearly this is a tough issue for everyone. So our role is really to get you to a point. I want to share some information with you to get yourself prepared as we get to a point where you're going to be able to start collecting again, give you enough information on how to document everything as to where you are through the pandemic and up until now, so that you're really in a spot to pull the trigger and get the collecting going and not have any setbacks. So we're going to cover a little bit about disputes. We'll cover a little bit about just the documentation trail. And first, we'll just start with kind of where we are in the climate of all of this. I heard from one of our, is it Tracy? Tracy, one of the gentlemen in our audience here was sharing a little bit about, I've done some research about the some of the assistance that's available. There's a lot of assistance that I'm going to talk about for renters, and there's also the Landlord Assistance program, and it sounds like there's some success and some money rolling there. So there is some good news on the horizon. Let's get into the meat of it. Were there any questions actually before I get started on background or anything specific that I haven't mentioned that you really want to get into? I'll see if anyone on there has anything for the Zoom.
I actually have a question for you.
Mm-hmm.
Considering the fact that there's probably going to be a lot of people seeking your advice and services, is there anything, and you might get into it, but is there anything they can do now, like well ahead of like calling you or sending you documentation to get the ball rolling before that timeline hits?
I think the main theme of what I'm going to share today is documentation on everything that you guys do. You're actually going to know more than I do about the process of the eviction and all of the paperwork that comes before that. I'm going to touch on how you make your file ready. So this presentation will really cover that, and it'll help set people up to have their file ready when the time is. We're really close. Let's talk about some of the timelines. There's been a bunch of House bills and Senate bills, right, that have gone back and forth through the last year and a half that have provided renters protections for, not being able to evict and not being able to collect on past due rents, and that is a protection period that is through the official, emergency period of the pandemic. So I think that can get really, really confusing. And in my research, I read through many of those House bills and many of the Senate bills and ordinances, and the timelines on those can get very confusing. So I took the main 5 that really matter, that are sticking, that are the key ones, and I've kind of broken them down for you here. And if either online or in the audience, again, I'm available for more information after this, because I don't think that we can really cover all the details really in an hour and get you through the documentation process. So just know that I'm going to touch on this a little bit. And if anyone actually knows more about this portion of it and doesn't want to hear this portion, if there's a larger group of you that know more about the House bills, I'm happy to skip on and get to the other information about preparing your file. So first, House Bill 4213, right? It passed the emergency measure for the pandemic. That's back in December of 2020. So that was the protection for renters not to get evicted during the pandemic period. So that was the main thing that started us off. And then House Bill 4401 extended that emergency period under House Bill 4213, extended it to the end of, extended the eviction moratorium then to June of this year, and it created tenant-based rental assistance. Then a separate House Bill, number 282, amended the payment deadline and made a grace period to the end of February of 2022. So really, all that means is a bunch of stuff went back and forth, things got extended, right? And so we're pretty much pushed out to just letting renters make up past due rents up until the end of February of 2022. So if you walk away with nothing from today's talk, that's basically it. That will be when it can start, and that's where we can really start working on this. Until then, our hands are tied a little bit, even though the moratorium on evictions and other stuff has come to an end in June and in September. You're going to want to wait to really take any serious action until the end of February. Sure. So a question from the audience, do they need to be making payments during this time? We will talk about, we hope they are, right? This is where the documentation, I think, is the key, because that's going to be the tough thing for the landlords, because it's going to be my guess that they're going to make a partial payment, or they're going to pay late one time and then not pay, they might pay once and then not pay the next month or whatever. So the documentation trail is going to be critical, because what it comes down to when you get further along in the process is at the very end of it, when you have a lot of rent due and they have been evicted and you get to this balance and you really need to try to get all your money back. The statute to sue for limitations is 1 year from a default. Well, now it's a giant question of when the heck was the default, because we have all of this mess going on for the last year and a half. So that's really what's going to be key about your documentation in your file, is to keep those timelines and to really document that stuff. In answer to your question, do they need to pay during that time? Well, the moratorium says you can't evict, and you can't do those proceedings, right? So you can't charge late fees during this time. So during the emergency period, really it's just a lot of hand-holding, and you're going to be in a better position setting up your file to collect the past due rents later. We're going to talk about some rental assistance programs, some programs for the landlords to get some money toward the past rent, and the renters too. So hopefully that's going to make up some of that gap. And in the end, with all the other information, hopefully that question will get answered more thoroughly. So House Bill 282 also provides some screening protections. I don't know if you're all hearing about this, but landlords need to be cautious about considering applicants. When you're considering applicants, you need to be cautious about considering unpaid rents that they currently have, and also be cautious about including and not include money that's owed through other judgments through the court for prior paid rents. So really, it just puts an exclamation mark on the fact that it's really, really, really protecting the consumer. And a lot of the things that we have in our lease agreements are not, I mean, usually you can feel confident with a signed lease agreement that you can enforce those terms. That's not the environment that we're in right now. So although you may have a perfectly valid lease agreement when we started out, some of these things are going to negate that, or at least delay them. Yes. So the question is, what types of judgments do you need to be cautious of when you're screening tenants? This is very specific to rent reflected in the court judgment. So, someone might have a laundry list of other judgments with other things, right? And you probably will be able to tell pretty well by who the creditor is. And it's all public record, so you'd be able to look at the judgment itself and perhaps the small claims case to begin with to see who the original creditor was. So you might be able to sort that out. I think it's just wise to just really, really be aware of that, because those are going to look a little bit different than other judgments, right? So based on the creditor and based on the dollar amounts, and more specifically based on the time frames. So it seems like this is going to carry on for a while with that kind of caution with new screening, because the pandemic's not over. We still, we have the Delta variant. We still have this going on, while the protections for evictions is going away. Who knows what's going to happen? Who knows if that changes? Well, these judgments and things are going to stick around for a while. So just a huge caution. The other thing, so House Bill 282 and their screening protections doesn't allow to refer debt to a collection agency. So not yet, but we're getting there. We're very close now. Evictions can't evict during the emergency period. We've already said that. No evictions or fees. This is kind of a weird one, but if you have provisions in your lease contract, this is a good example of one that's really not enforceable at this time. You have them, you have a maximum number of days that guests can be there, and you're not at this time able to charge any late fees if those guests stay beyond and so forth. So I only mention that just because I wanted to really point out that you want to look at your lease agreement and get legal advice on those before you would make any move based on the terms of those agreements at this time. Also, no credit reporting on delinquent unpaid rent. So who knows how long that will go. A little bit more on the some Senate bills, and then we'll get into a little bit more of the information that we're really here to get on how to get paid. So Senate Bill 278 can't evict for unpaid rents if they have applied for rental assistance. So landlords are prohibited from serving any termination for unpaid rent or evicting for unpaid rent if they apply for assistance. Now, the landlord is required to attach, I don't know if maybe you guys are already all aware of this, and I have a sample to pass around if you're not. Landlords are required to attach a notice of the renter's right to avoid termination. And of course, it has some specific language in it. You need to give them their rights in writing, how to avoid termination and eviction for non-payment of rent. If they have a documented application for rental assistance and the tenant has provided it to the landlord, and that gives them protection through February of 2022. Do you all work with that notice already, or would you like to see it? Does anyone? Okay, I just had the one copy, and I should have started out saying this, that I'm not an attorney and I can't give legal advice, so I need that back. Don't photocopy it, but you can find it on your own and get one from your own legal counsel. Okay, so this law made landlord compensation funds. Someone in the audience I mentioned earlier, Tracy, correct, was telling me a little bit more about this. I think you're more knowledgeable about the Landlord Compensation Fund that provides funds for landlords, so landlords can apply to actually get paid for unpaid rents. And it sounds like, from at least Terry's experience, that they're even paying ahead. Is that what I remember you saying? Not on that. Okay. Okay. So for the Renters Assistance Program, you said. So with the landlords, with the Landlords Assistance Program, they're paying more on it. And what you might want to consider is waiting until you think you're maxed out on that past due rent before you apply for that, so you're not going back and forth or using up that resource too soon. There is also Ordinance 1296, almost done with the bills and the ordinances, so Ordinance 1296, Multnomah County, effective July 8th of 21. Change the grace period from 60 days to 90 days for renters. And so we're talking about there, they apply for assistance and they let the landlord know they have some additional time to get that process to go through the system. Okay, so enough with the details of the laws and the bills. Did anybody pose any questions on that before we move on? Okay. Feel free to interrupt me if anybody has a question and I need to go back there on the Zoom. Yeah. Right. So the question posed in the audience is, if the tenant is provided with their rights in writing that we're required to do, and they have questions about those, do we necessarily want to say go seek legal advice, or how do we handle that situation? I think that's a very perfect segue to talk a little bit about the difference between first party collection and third party collection. So I'm third party because I'm a collection agency, and I'm going to take on everything that you were not able to collect and try to get that for you. But I would, as a third party collection agency, have to basically start over and redo everything you did, provide more documentation than you did, and then I can go on and move on and do my stuff. So the question you're asking is, if they have a question up front, my recommendation, and this is my recommendation with any consumer debt collection at all, is that you have a lot of ability to negotiate and use your empathetic methods, negotiation skills, reasonable attitude, and you know, work it out with them. So they may have questions that can be answered elsewhere, and there are other resources, so they can definitely go probably get those questions answered by free legal aid or something like that if it's very contractual, and you probably don't want to be acting like any kind of an authority on the notice. The notice you're required to give gives the language. Beyond that, my answer is be reasonable and empathetic, and make sure that you're documenting and staying within these timelines of the House bills, the Senate bills, the ordinances. Just make sure you have a good understanding of those dates and times and deadlines, and document well. Does that answer your question, do you think? Okay.
So if a tenant, after you send that document, willing to negotiate, let's say they owe 20 grand back, they say, hey, I'll give you 15
Yeah.
over the next 2 months.
Yeah.
Would you just take that?
Yeah.
If you're your client?
Are you asking that from a collection agency standpoint, or from the landlord standpoint? From the landlord. Mm-hmm. Mm-hmm. Right. Right. Okay. So I think I understand the question to be, in that early stage, if the renter is very far behind and want to offer settlement, is that a good idea to take it? So anytime you're dealing with, my strategy would be, anytime you're working with someone and negotiating, you want to put yourself in a very knowledgeable position to know what it's like, to me, a game of cards, right? You can ask enough questions for them to tell you what cards they have and what they have available, what the resources are, how likely are they, do they have a job? Is it a job that they're going to keep? Like, what's the availability of getting the money if you don't take the settlement? So there's going to be a lot of times where the settlement might make more sense. It might be, you know, a family member helping out with a withdrawal from a 401k and you can get paid in full, whereas you could be 2 or 3 years down the road trying to collect unpaid rents. You could get a judgment for $25,000, but are you going to be able to collect it? So that's really just juggling, getting a good idea. And in the documentation trail that I'm going to suggest, and especially coming from a collector standpoint and a legal standpoint, when you get way down the road and you do get a judgment against these people, you sue them, you get a judgment, and you're ready to enforce that. The only way to enforce it is to have a bank account, have wages that are good, and they can't have a bunch of other judgments and wage garnishments ahead of you. So that's all the stuff that you want to consider. Like, what is the likelihood, right? So make your strategy. So I say the number one strategy always is to negotiate and ask a ton of questions. Find that out. Are their family members helpful, or have they burned all the bridges? They usually vomit information as soon as you start to ask. And especially if they think they're getting something, they're more willing to give out that information. So usually I'm not going to walk up to you and go, Taylor, where do you bank? But we're in this conversation about, okay, well, I want to pay you this. And okay, well, how would that be? Would you like transfer from your bank? Oh, what bank would you be transferring that from? I mean, you can just get those sort of questions in there along the process and set yourself up. How long have you been with your employer? A lot of that information might be available from their rental application, but then at the same time, that's probably changed during COVID. So you're free to ask those questions, because that's going to set you up for collection later. Okay, so I actually forgot to set my timer. So where are we at the time? Okay, that's fantastic. That's fantastic. Okay, so I'm going to move on to a little bit about the climate of landlords getting paid in rent right now, a little bit of information that I've seen. So according to the U.S. Census Bureau, I'm seeing that 17% of renters have little or no confidence in their ability to pay rent next month. I'm sure you can probably share with me more details about that information. And one or two of you in the audience have had some experience with that. My experience with the percentages is that in the collection industry, if you're over 1 or 2% in delinquencies, you're in trouble. And I'm hearing that delinquencies are more like 5% right now. 9% of renters is what I found from the U.S. Census Bureau. 9% of renters are behind on their rent right now. So this is a serious issue. And again, the moratorium didn't take away the rent that's past due. It just pushed it out. It just pushed it out. So according to data at the Oregon Law Center, there's been a spike in evictions, which makes sense, since Oregon's ban on the residential evictions for failure to pay rent ended in June of 2021. There were, in July, Multnomah County, 361 eviction notices filed. In August, another 267. So that's compared to 66. Only 66, of course, of those evictions were filed during the ban period. So those were most likely for other things and not unpaid rent. Otherwise, they would have been in violation. So good and bad news about that. There was a federal moratorium effort that was intended to last until October, but that was thrown out by the Supreme Court, so we don't even have to discuss that. Oregon unemployment rate dropped, so hopefully people are going back to work, but then again, we do have the Delta variant and the unknown factors of the continuing pandemic, so we don't know what's going to happen there. And so rent assistance options, I won't spend too much time on this, but I will spend some time on how to juggle the timeline of the renter's assistance, the landlord's assistance, and balance that with your documentation and getting it to a collection agency at the right time so that you still have the option to sue for the debt before the statute runs out on it. So as of 2021, renter's protection, it was given for 60 days. Now it's 90 days after they apply for rent assistance and notify the landlords. Multnomah County did extend that through the ordinance that we talked about earlier. And there's a few parties that really, anticipated consumer protection. So lawyers and caseworkers basically are the legal supporters, right, of the tenants. And so what is being seen now is if there's money going toward, there's money going toward this defense program for them that didn't used to exist. So it used to be that renters were not well represented when they got to the eviction process, when you go to court, and not well represented when they're taken to small claims later. And now that's anticipated on, that's, that percentage anticipated to go up. State Landlord Compensation Fund, landlords can apply to get reimbursed for missed rent through June of 2021. And it sounds like, again, as I said earlier, that that's going quite well so far. That seems like a blessing. Renters Emergency Rental Assistance Program. So the renters may apply to the state to get federal funds to cover back rent, possibly up to 3 months in the future. So a caution about that program, though. So we talked about the extension of the time before landlords can evict, but what about those renters that applied late or did apply, and then this is what I'm seeing or hearing is that there's a backlog in the system. So a lot of those applications are getting aren't processed yet. So that's where I want to say back to the documentation trail to get your file ready, is to be very cautious about if you've been notified or think you haven't been notified yet. Investigate when did they apply and try to get that documentation of when they applied in your file, and then wait it out, because it might be in a system, but there's a backlog. So it says only about 10% of assistance applications have been processed. And that's as of late August when I started preparing for this. So it's just due to a software problem in their centralized system. So it's meaning basically a bunch of the applications are blocked out, right? So they might be in there. Then again, your renter might be lying. So who knows, right? But I would say better safe than sorry, but I'm also a landlord who wants the documentation. So try to get the documentation. Any system that they enter should give them a receipt there should be some sort of acknowledgement. So they should be able to provide you with some proof of it. Okay. So while the assistance is being delayed, what's going to happen is many of the Multnomah County tenants are going to lose their eviction protections. That's going to make us want to be able to take action, but I would be cautious. And if you can prevent, further delay your actions, because once you start an action too soon, you can't unring that bell. So I would be very cautious about starting an eviction process or starting a suit process or any of that before you're really, really, really certain that you're in the right spot. So have your deadlines, have your file all together, have all your documentation together. I have provided too, I was going to jump to this later. I feel like there's a question coming. I provided a little bit of a checkoff sheet too of all of the stuff that I would say to have in the file, and just the mental checkoff sheet that you would want to have before you take any action. So it's pretty simple. It's like 10 items, and they're all pretty obvious things. But what we see in collections and in legal work a lot is what ties our hands the most when we go to enforce things is that one of the 10 obvious things is missing. And then it kind of just makes a mess, right? And so we have to start all over, or we can't enforce something and what would otherwise be a really good case. So I can't stress enough documentation and paying attention to the deadlines. You have to be able to prove on paper that you were extremely reasonable and consumer friendly. So show that on paper, because you're going to be pissed off about non-paid rents. You're going to feel very passionate if you're there, your own personal property, whatever, but it doesn't matter. It has to be on paper. You have to be able to prove that you're reasonable. So that's going to include emails, text messages, all of that. If you're going to use one of them, you're going to need to provide, if you're sending it to a collection agency or doing it yourself and end up being in court later, you're going to need to provide all of them. So just keep that in mind with your language as well. And just, go in it with a conservative, kind language, and keep all your documentation. So, so back to this lawyers and caseworkers supporting the tenants. The Oregon Law Center anticipated a spike in the eviction cases, right? And started staffing for it prior to the Oregon moratorium expiring. So they're ready to come to bat for these renters that they know are going to end up in eviction. They are getting money from Multnomah County to have 2 lawyers and a paralegal specifically dedicated to this topic. This nonprofit is contracted with the city of Portland. So there's the whole eviction defense program, and tenants can call 211 for Multnomah County Eviction Prevention Team. I'm going to tell you that. I don't know, maybe a little bit in answer to your previous question. I don't know if you want to be posting that, providing that, whatever. I would always stick to language that's provided from an attorney or from your own legal counsel. I'm not sure that I would give out extra information on a defense fund or on a defense program, but it is there, it is public, it is available. So what that means is these guys, caseworkers, are milling around at the courthouse now, and they're walking people through the process. So they're going to get, a lot of people are going to get the help that they need to get through that process. I have the phone number for the Eviction Defense Project. One of the things I like to do as a strategy in my work is know what the other side is and what their resources are. So if I were you, I wouldn't hesitate maybe to call that number and inquire and see what kind of information people get, and see what information they're being provided that they're going to use for their strategy with you, right? To maybe avoid rents and avoid evictions. But just knowing all of the information and all the resources available, I think, is a smart move, and you can strategize accordingly. So also, the Metropolitan Public Defender's Office is watching for the basic blunders on evictions. And my guess is that's not going to be too hard to find. So I will reiterate, I think I've already said it like 25 times, but documentation, make sure you're following the guidelines and the deadlines, documenting everything, avoid the blunders. The 2 things that they're really looking for, basically they want us to mess up, right? So they're going to look for failure to give renters a 10-day, failure to give renters 10 days to pay missed rent after, or by issuing a termination notice. and then trying to evict for rents that were due April of 2020 through June of 2021. Again, renters have until February of 2022 to make up those payments. So those are the two things really that they're looking for, and they're going to look for those blunders. And that's going back to, again, if the documentation isn't there and the process isn't right before you get to the legal process, then you don't really have the legal process to, you can try to sue, but you might end up with a counter sue and you might end up paying out instead of getting paid. Yes. For the second one, the dates again are, don't try to evict for missed rents where the rents were due between April of 2020 and June of 21. So remember that as of July, they had to start paying the rents again. So that's what you want to do, is make sure, however you keep track of that, that it's not for those months that you're trying to evict, at least not yet. Okay, so usually half of landlords are represented in eviction proceedings, and about 6% of tenants are typically, so that's before COVID. With these resources that I just mentioned, the Oregon Law Center and the Defense Fund, the Defense Program, they have dedicated people on this all the time. So I'm anticipating, right, that we're going to see a lot more renters being represented, and they're going to be a lot more informed about their rights. So that's not horrible. It just means we need to be really, really good at what we do and understand what we're enforcing and do it at the right time and so forth. So we're dotting all our I's, crossing all our T's, making sure we have our ducks in a row before we take action. All right. So, yes, question. Mm-hmm. Mm-hmm. Mm. Yeah. Well, so the question is, with the assistance do we think that the staffing on the other side is sufficient, or, right? So I'm sorry, I'm not paraphrasing your question very well. Do we think that the staffing on the other side for the renters protection is adequate? And I'm going to guess, and most things governmental, no. Well, I want to take a guess. I mean, I don't know. I'm still waiting on plates for my car from 6 months ago, at DMV. I don't know. So it's hard to tell in this environment. I would 2 lawyers and 1 paralegal, which is not a whole lot, right? But it's money going in that direction. It's allocated money. So, I mean, really, it's the effort, and it's still gonna be consumer friendly. So, that brings me to just because there are a lot. It's easy. Anybody can sue anybody, right? So anybody can throw out a suit and get paid settlements for. There's one attorney that I work with a lot. I won't say his name out loud, but it's a very commonly known name that basically what he does is just sue for random stuff, right? And we all see his name coming, but what ends up happening is he does it in such volume that he gets paid. He just gets paid to go away. So it doesn't even legitimize what his claims are. He can claim anything he wants. And that's sort of my guess is what we'll be looking at here, is the burden is going to end up being on us when we think we misstepped or they think we misstepped. We're going to have to really, really defend ourselves. So that's why, again, I say the documentation so that you are prepared to defend yourself. But as far as staffing, yeah, probably not. But you're definitely going to see more people having their rights protected. And I would guess that it's probably going to be a new group of attorneys that go, just like an ambulance chaser or any other, like whatever, right? They're going to probably go, oh, here's a new little slot that we have tons of people here that we can represent. So I wouldn't be surprised. Yeah. 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 So sort of like we said before about the settlement, thought process. Do I take the settlement? I think it's the same when you're challenged with a dispute, because as well, if it's in the first party, if you're just negotiating, you have more ability to just work it out. Once you've done all your documentation and actually taken an eviction action, got to the legal process, maybe with the collection agency doing work for you, as soon as they raise that, then there's all kinds of other stuff that come into play about the more documentation that we will need to provide. And if there's a hiccup in that, that's what the attorneys are looking for. Easy money, right? I'm not insinuating that all attorneys are just out to make money and not represent their clients, but I mean, that's not right. I'm sure they're so anyway, enough said on that, but it's all, it's all strategy on their end, and anything consumer related where the consumer can easily be perceived as the victim, the burden is going to be on us. So it's going to make it harder. So I'll talk a little bit about, I'm sorry, can I do a time check again? Okay. About 20 minutes, less than 15, 20 minutes. Okay, that's a good time. Okay, so how about we talk about a little bit about solutions? So we do want to be able to collect past due rents, and we're going to be able to here pretty soon. The placement process is something to think about with the collection agency, and sort of think ahead about how that timeline would work, because most debt has a statute of limitation to sue on it. Most debt is 6 years. So that gives us lots of time to mill around, keep asking for payment, get some, have them continue to be late before we can sue. But lease agreements will be different, especially consumer lease agreements. We have to sue within 1 year of the default. And I think I said earlier that now how do we define what the default date was? Okay. Any other question, Taylor? Okay, that was, okay. So it's going to be uncharted territory, I think, and that could potentially be some of the stuff that comes up with potential attorney claims or whatever. Is probably some argument over that. I'm just going to guess. So here is something to think about in the process. Thinking about the timeline and to get yourself in a position to get the money collected before it's too late. So I did say that first party in your hands is going to be the best way to do it. It's still true information. But now where you're going to be able to start collecting by the end of February, get your notices in order, understand what those need to say, probably provide some extra empathetic language, do whatever you have to do in advance to prepare for that so that you can make that happen as swiftly as possible, because you don't want to take a lot of time if you think that you might shove these to a collection agency later, because if you have volume, you might not have the staffing yourself or the time and ability and resources to actually do all your collecting. So if you are wanting to accelerate those and get them to a collection agency, think about this timeline. So you can start collecting at the end of February. Most people probably aren't going to just be able to come up with their lump sum right there. So first step, talk about the settlements, consider the strategy, all the stuff that we already talked about there. And then if you have to move on, when you assign it to a collection agency, you're not going to be able to do that for a minute. But when you do, after that February, March, you give them some time to make that up still, then get it assigned to a collection agency. This is what to expect. There is a validation period that happens when it gets signed to another party. So it goes out of your hands from first party to our hands. I'm going to say us as the collection agency, assuming you're all going to come with us. But there's lots of agencies available. There's a validation required by law, a period of 30 days that we need to give them. So as soon as you give it to us, we check for, are they bankrupt? Are they deceased? We do a bunch of stuff to keep everything safe, and then we begin to send notices. And that first notice required by law gives them 30 days to dispute the the validity of the debt. Most people don't dispute the validity of the debt, but when they do, it changes the timeline, right? It sets us back to getting all of the documentation that you have. I have to provide them, or I as the agency need to provide them with all the documentation you have and get them to agree. So that, you know, that takes 30 days, 60 days, whatever. They could argue some more. I could ask you for some more documentation. Just know that's there. But generally speaking, the validation period, first 30 days, disputes, you know, take a couple months, like we said, and then there's in that period after it gets assigned, after a few days, we can begin to call. We have, or I'm saying I'm not actually telling you about Western Collection Agency or Western Collection Bureau, but just the process, right? So a collection agency is going to begin calling pretty soon. They can call during the validation period, but not be able to accept settlements. So there's some legal stuff going on there. Collection agency will do calls, a series of letters. Beyond that first validation letter that gives them 30 days, there should be at least 2 more letters. You should expect a letter 2 to go out as sort of a reminder. A letter 3 is going to be more of a demand language. And then after that, you should probably be at around 90 days since you assigned it. And then there's going to be the few months in addition to that, since they defaulted, right? So we're trying to get to the point of being able to file for legal action before that statute runs out. So just break that down, right? You're gonna have to look at all your files, do whatever you can to have a staff, maybe, you know, get your bean counter in the office or whatever to line those up and figure out what those dates need to be so you can meet the deadline. But we're going to, an agency is going to need a good 60 days to go through the validation period, the collection letters, the calls, all of the talking back and forth, negotiating. If it's like other debt, a good percentage of it is going to get paid, and then a smaller percentage will have to go to legal action. And when that happens, what a legal person is going to be doing is going back to where we talked about before, is what are the resources of this person. The more information you can have, like the bank account, like a good employer or assets or things like that to provide an agency, the better position you will be in to get your money back, because they'll be able to use that, verify it, and use it to actually negotiate and or sue and get collected, versus when we don't know anything about this person's resources. Your agency will look for it, but then we're going to be talking high volume and things like how big is the balance. A larger balance may be more worth pursuing than another, and so forth. Go ahead. I wouldn't go a year before you assign it, because you're already going to be butting up against the statute after we sign it. So after it's assigned to us, we still have a statute of limitations to sue from the default. So that's going to date back to when it was with you. So that's why I say you'll kind of have to coordinate your timeline of getting it assigned in a reasonable amount of time, but then also a reasonable amount of time for you to have done your diligence and not go, oh, hey, it's March 1st, I'm assigning this. And they just got through the grace period, right? So still be reasonable. But yeah, so that's gonna be, I think, a tight timeline, because usually, like I said before, we usually have 6 years to go on debts, and generally speaking, most things either get paid with an agency within 2.2 years, or they're at legal action within the first year and a half. But we don't have a year and a half to wait. We have to notice these, and agencies have hundreds of thousands of all kinds of accounts. So if you want yours to get in time, you probably want to even talk to like whoever you assign, get a good relationship with your client services person, so that they can keep an eye on those particular ones. Otherwise, they might not get noticed before that statute expires. So you can be your own best advocate there. And then again, because I haven't said it in like 5 minutes, documentation, provide them with everything. Don't hold anything back. That could be a really difficult, that's one of the most difficult things when I go to sue somebody and I find out that there was information I didn't know. I don't care if it's bad information, as long as I have it and I know what I'm dealing with, I can work with it. Question? Mm-hmm. Yeah. Yeah. So the question is documentation, email, and text messages, screenshots are fine? Yeah. Yeah, I have seen manipulation of emails, right? Because that's pretty easy to do. People, right, submit stuff that's not saying that a client would ever do that. I'm just saying it's out. So it's good. I mean, we need to have all the information, and then it all gets sorted out in court if they're needed. But what a legal person's going to do, or at least what I do, I will say that a good strategy for assessing a file is to know and have all the information and dissect everything. And this would be a good thing maybe to, when you interview for a collection agency, if you don't already have one, is to get an idea of what their level of knowledge and expertise is. And if they do it, just because they do high volume might not mean that that's going to be the best process for you. Now, maybe it is if you have a lot, but I would say do some diligence to investigate and find out what their process is. We do a lot of legal work, but we do the ones that make sense. And in my history, I've had a very good history. I really have never lost a case. So I want to be confident when I go in there that I have everything that I need and there's no surprises. That means to disclose all the arguments and all of this dispute information too. That's really critical. So in an agency deciding if they take legal action for you later, what is involved with the dispute? A bunch of people are going to argue and generally not like stuff. That's not always considered a dispute, but if they bring valid information to you, don't blow it off. I mean, if they're saying you missed a deadline, you missed a day, you didn't pay attention to this, House bill or whatever, take pause and make sure you did. That's all stuff that we're going to look at, but we're going to redo all of that and be your representative for your agency or whatever agency you choose. So negotiations are big. And when you assign that to an agency, you might expect also at some point for the agency to say, hey, this is what we think maybe a 75% thing might be better for you at this point, but we're going to want to know what your limits are. We're not going to suggest you take less. If you have a really good case, we're going to tell you that. So then again, it's going to be your decision on how many you want to take that far. Does it make sense for you? The expense is going to be taken off what is owed you and so forth. Something to mention is in Oregon, small claims are up to $10,000. So you can file your own small claims, and I can walk you through those. An agency can do that for you too. Anything over 10,000 needs to be done by an attorney. So then you're getting into some big money. So is that what you're saying, that the debtor suggests less, or the client says, go ahead and take less? Yeah. Mm-hmm. Yeah. Mm-hmm. Yeah. Yeah. So the question is, do clients sometimes allow the agency to take less money or to negotiate a lesser balance? And the answer is yes, but it does really depend on the client. So a couple examples in our agency, we have some attorneys that we work for that just say, you just do whatever you want and we're happy with what you get. Or an accounting firm that we work for says it needs to be X amount. So anytime I do a case, I know I'm working with an 80% figure or something like that. So your client will generally give parameters. And so you as the landlord or whatever, you can do that. And that will usually come at the point where you're dealing with your legal staff with the agency. It's generally, you're expecting to get paid in full at the standard collections through the first 90, 120 days or whatever. You should be expecting to get all your money back with whatever you pay the agency to do standard collections. Beyond that, your legal staff, then you can negotiate, definitely. And something I would suggest when you get to that point is to really, really have a figure in mind of, know what that figure is when your legal person asks you, so that they can go in armed. The way I handle it is I get that figure from them. I always sue for the most that we can get. And I have a whole range of where I'm going to negotiate that I never say to them until I need to play that card. So almost 100% of the time I can give the client more than what that bottom line figure is. But again, that's interviewing your your agency and your staff and who's going to work for you and who's going to do these cases. Back to the small claims though, you can do them yourself. It takes some coaching. It's a little, you can do them. I mean, anybody can really file a small claim, and then it's the collecting on it that could be the enforcing it that could be the challenge. Again, you can get in contact with me, and you can't get advice from the court on that, but everything's online about how to do it. But like with a lot of legal processes, it might look like it's easy to do, but you might want to have some coaching on someone who knows the process. So once you sue, you get a judgment, then you need to garnish them. That's a little bit more complicated, but you can still do it yourself. So all of this is totally available for you to do as the first party. If you're staffed to do it and you feel confident doing it, you want to do it as inexpensively as possible, you can do small claims, but you can also consult someone, and an agency can do it for you. All right. How are we doing on time? Okay, 5 more minutes. So this is, okay, my favorite topic in the world, which we don't have a lot of time for. So again, I'll offer that we can, if anybody needs this, I'm available. And I usually I do more presentations on creditors' rights in bankruptcy. That is really my specialty. So as we said in the beginning, with all of these past due rents, more than likely you're going to have an increase in bankruptcy filings. Just sort of makes sense, right? As more evictions and foreclosures and all this stuff starts to happen, and all these back rents. So I teach on bankruptcy rights of the creditor. So usually what happens when you being the creditor, right? So somebody owes you money, you're a creditor. You get served with a bankruptcy notice. Bankruptcy is a really, really, really complicated issue, but the really basic, simple thing about bankruptcy is that there's 2 main things. You have a stay of action as soon as they file that case in the bankruptcy court. And what's tough is they don't have to notify you. You're supposed to know. Well, how are you going to know? How are you always going to know unless they tell you? Hopefully they will tell you, and they will give you the notice, and then you won't violate any rights. There are huge sanctions for violating bankruptcy rights. Don't do it. Just don't go there. The stay of action is you cannot attempt to collect a debt, continue any legal action. So that's going to be eviction or legal process that you're already in the middle of, or exercise control over collateral. Now that's going to be more like vehicles and for lenders and things like that. But I wouldn't say that it's totally out of the question that there could be some legal argument about possession of the place. I don't know. Collateral is really right what helps you get paid. So that's probably not an issue, but those 2 main things in the beginning, as soon as on the date stamp of their bankruptcy filing in the court, whether you know it or not, your actions are stayed. You cannot attempt to collect a debt, and you cannot exercise, or you cannot start or continue legal action. So that means it's up for interpretation. Make it simple on yourself. Make your policy that to attempt to collect a debt is going to mean phone calls, text messages, emails. That might even mean answering theirs. So really be careful. Get legal advice. If you don't already have an attorney on staff, find someone. Be prepared for that. If there's a stay of action in the beginning, then they're going to get through a 3 to 5 month period on Chapter 7, where basically everything's going to go away and you're probably not going to have a chance of getting paid. If they file a Chapter 13, it means they have income resources. You might know that if they actually do work now or they have other income. That's going to be a 3 to 5 year process. And my recommendation, again, get legal counsel because you may want to exercise this, but a couple steps you can do on your own rights is always file a proof of claim in every single Chapter 13 bankruptcy case. 100% of the time, file a bankruptcy proof of claim, and I can show you how to do it. It's not tough. It's online. It takes fewer than 5 minutes. I can tell you it's easy, super, super easy, but 100% of the time, file your claim, because if there's any money to be had in the bankruptcy, you want to get in line, and every other creditor is going, I don't know what to do with this, and they're going to throw away the bankruptcy notice and write off their debt. So be in line. There could be 50 creditors, and you could be the 1 or 2 or 3 that's in line for their income. Okay. All right. Well, I think we're about at time. I could go on forever about bankruptcy, which is my very favorite topic, but Are there any questions that were posed online or anything that I didn't answer here? Okay. Yes.
Yes.
Mm. Right. Yeah. Right. So the question is, does it make sense to go through an agency for small claims if you're owed back due rents on these? So generally speaking, an agency is probably going to charge somewhere around, a percentage for just basic collections. Like that's going to be the negotiated contract with your agency through calls and letters and whatever with just collectors. So you'd probably be looking at, you assign a balance, say the whole thing gets paid in full. The fee that the agency keeps is going to be like 25% of that, maybe 30%, whatever you negotiate on your contract. When it gets to legal action, we're going to front legal costs for you. And then when we get paid, we're going to take those back first. So we're even. And then the rate we charge based on the balance of the account is going to be 50%. And that's probably going to be pretty common of what you would find of any agency. Where that number increases on the amount that you get back, though, is there's going to be accrued interest. So Oregon accrues interest at 9%. So at time of assignment, based on your contract or whatever, we're going to take that interest of the 9% and have that accrue back as far as possible. And we can get that in a suit and a judgment and so forth. Another thing in the documentation is Nsf checks when you get to suit. That's probably a likely thing, right? Later on down the line, if you don't have someone advising you, make a mental note to figure this out. There's a statute that you can sue for the balance that's owed to you, plus damages under this particular caveat, this particular statute, that is 3 times the amount of the Nsf check item, up to $500 more than the check, plus the bank fees. And then that's the damages. So put that on top of what they owe you. So, just as an example, a $300 balance could go up to 900. So proportionately, when you have bigger balances, right, that could be bigger. So, and that's in small claims court. It can help out, and the interest accruing. Most agencies will keep the interest. A lot of them, our particular agency, we split it 50-50. So we want to be able to give you as much back as possible. So we'll have it accrue as much as possible, and we'll split it, and then the 50% on the legal action. So to answer the question, legal action is generally 50%. And we consider legal action anytime it gets to the point of having a legal person involved. So once a dispute or bankruptcy or a suit or any of that happens, then clearly it's a legal account. All right. Well, all right. Thank you, everyone, for having me. And let me know if you have any questions. I have my cards available in that checkout sheet if you wanted to take that home with you.
Thank you, Gina. And I want to just reiterate to everybody out there, if they have questions, you have information for them, they can contact you and you can help them with some of this.
My boss will love that.
Your boss would love that. What's a good way to get in touch with you?
I did leave my cards. My office line at Western Collection Bureau is 503-496-0732. You can just Google Western Collection Bureau. We're on Beaverton Hillsdale Highway. We are in the process of changing our name to Western Agency, and we are also the commercial agency. So any of those ways you can get a hold of us. And then I'm randomly online for doing other things. Gina Whitlow, WHITLOW.
Wonderful. Great information. There's a lot happening out there and hard to do it by ourselves. We need a professional, I think, to help us with all of this. So I learned a lot tonight. I know a lot of us did, and hopefully some of you out there watching on Zoom learned a lot. You can share with your family and friends and clients that you know. If they have any questions, make sure you reach out to Gina. All right. Thank you. And I hope you all have a great night.
Thanks.
Okay, we're going to wrap it up. Taylor?
I don't have too much to say other than Gina does swim with sharks. She let me know that. So she is she's not afraid of the danger. And for all Westside Investor Network events, they are recorded at westsideinvestorsnetwork.com. And please check out our podcast at the Westside Investors Network podcast. Thank you guys for tuning in tonight.
Thank you. Yay.